there, Wicked Title folks. Cheryl here, your resident FinCEN compliance translator with an update. For months, a lot of title shops have been operating under the same unofficial project plan of, let's wait and see what the lawsuit does. We'll panic later. Well, later is now. Cue panic. So here's what happened. On February 20th, Judge Wendy Berger granted a summary judgment in favor of FinCEN. In plain English, Fidelity's legal challenge to the residential real estate reporting rule failed. The rule stands, and the industry's maybe this goes away exit ramp just closed. This is no longer a maybe. This is not a wait and see. This is happening. So the question isn't whether the rule survives. The question is whether your agency is ready by March 1st, 2026. You heard that right. March 1st, 2026. That is literally just days away. So let's talk about what this actually means. This rule, called the FinCEN Transparency in Residential Real Estate Rule, is an anti-money laundering regulation, also known as AML. It targets certain non-financed residential transactions. Why? Because real estate is known as a money laundering tool. Here's how it works. Dirty money is used to buy property. The property sits, time passes, the property is sold, and suddenly those proceeds look like any other clean escrow transaction, and the money goes back into the banking system looking legitimate. The goal of this rule is to interrupt that process. So let's talk about what you're going to have to do differently in production so that you don't get crushed by it. First, who has to report? FinCEN calls them reporting persons. That includes title insurance agents, settlement agents, escrow agents, and attorneys performing closing functions, and sometimes even underwriters, but that's going to be pretty rare. Responsibility follows what is called a reporting cascade. The party most involved in the closing bears the responsibility unless there is a written agreement designating someone else. Wicked translation, if your shop touches closings, assume you're going to be pulled into this, either as the filer or as the party everyone stares at when nobody wants to be the filer. So it's also important to understand which transactions are reportable. This would be non-financed transfers, meaning all cash, or financed by something other than a traditional lender. For residential real estate, where the buyer is a legal entity or trust. So let's decode some terminology and dig into these details just a little bit more. So first, new labels, because apparently we always need more labels for parties that we already know. Thanks, FinCEN. So a transferor equals a seller, and a transferee equals a buyer. The buyer's status determines reportability. The seller's status does not. But if the transaction is reportable, you're going to collect information from both. So does residential mean what you think it means? Yeah, and more. So we are talking about 1 to 4 family homes, townhomes, condos, co-ops, even small multi-units. And it can also include vacant land if the buyer intends to build a 1 to 4 family structure on it. So make sure you ask, because we just need more questions. This applies nationwide with no geographic carve-outs. So let's talk about what you actually need to report. So get ready to get up and close and personal with your buyers and sellers. You may not quite be asking the color of their underwear, but it's going to feel like it. You're going to need property details, total considerations, and payment breakdowns. And you're going to need buyer and seller information, including names, addresses, taxpayer identification numbers, citizenship details, and more. I can hear the suspicion in your voice already as you're asking, what kind of more? Well, that's going to depend on stuff. It could include information about the person who will be signing the paperwork because that might not be the owner or the trustee. It's also going to include information about who owns the trust or the LLC and details about those owners. And is the trust have an LLC for the trustee, which is then owned by another LLC? Shell companies are like Pokemon. Gotta catch them all. FinCEN has released a read-only preview of the real estate report form, and I've linked to that in the show notes. I highly recommend you take a look. Don't guess at what you're collecting. See it with your own eyes and make a plan to catch it all. So once you've collected all that information, how and when do you file? You will be filing online using the BSA e-filing system, which I have also linked to in the show notes. You need to file within 30 days of settlement or by the end of the month following closing, whichever is later. And you have to register to use that BSA system. So please do not wait until the 31st of the month after your first reportable closing to discover that you don't have login credentials. Go sign up now. That way it's ready to go whenever you need it. So another big concern with this is the concept of reasonable reliance. FinCEN has declared that you are allowed to rely on the information provided to you by other parties if it's certified as accurate by the transferee. So, said a different way, you need to add something to your closing package that the parties sign stating that the information they provided to you is true and correct. And if you really want to get fancy, you could throw in an indemnity and hold harmless clause just for funsies. And also, you can't unknow what you know. So if something obviously looks inconsistent, we were told is not a magic shield. And finally, there is the record keeping. According to FinCEN, you must retain the required beneficial ownership certifications, designation agreements, and any certification supporting reasonable reliance for 5 years. Now, most of you already retain records longer than that because of state requirements, so this might actually be the least painful part. FinCEN also notes that you are not required to retain a copy of the report itself, but personally, I would just keep it all. Which raises an important question. Can we charge for cloud storage fees at settlement? Is that a thing? I feel like it should be. Anyway, if you've been in the wait and see camp for the past year, you might feel behind. So let's try not to panic. I'm going to give you 3 small actionable steps to get you started. Step 1, decide who is in charge of the following. Who is in charge of flagging potentially reportable files? Who is in charge of collecting the information on a reportable file? Who is in charge of getting a reasonable reliance form signed at closing? And who is in charge of filing the report? Now, that might be 4 different people. It might be 1 person. Depends on your operation and how you run things. But make sure you know who. Step 2. If you don't have a secure client portal for exchanging sensitive data, go get one, like yesterday. Seriously, you should already have this. Emailing social security numbers is not okay under any circumstance. Step 3, schedule some time for training. And speaking of training, if you're not a member of the Wicked Title Knowledge Base, now is the time. I am currently updating and publishing the fully revised Title Agent FinCEN Compliance Guide. This includes reporting flow charts, cascade breakdowns, staff slide decks, intake templates, certification language, designation agreements, screening checklists, communication scripts, all of it. All of the things you could possibly need to train your staff, process all of this, links to all the important places that you need to go. Everything you need, nothing you don't. Headlines tell you what happened, but members learn exactly what to do next. This has been Cheryl with the Wicked Title Forum. Until next time, Title Sharks, keep your fins above water and don't stop moving.